Hey, you guys. All right, today we are going to talk a little bit about the judicial branch of the federal government, and then we are going to go through some of those landmark cases on that paper that I attached to RenWeb. So the first thing, you got these papers that you're going to be reading this week about the judicial branch, and we're not going to cover every single thing in here, but I do want you to read it. So basically, the judicial branch is our court system. And we have court systems that are local, we have court systems that are statewide, and then we have court systems that are federal. And the judicial branch of the US government is basically mostly talking about our federal judges and our federal court system. So if I commit a crime in Houston, Texas, I'm going to be tried in Houston, Texas, right, in a local court or a state court. But when things happen and people think they're not fair, it gets elevated and they do something called an appeal. And so they can appeal to the next higher court. And then if they don't like that decision, they can appeal to the next higher court. And if they don't like that, they can appeal to the next highest court. So that's how things kind of climb the ladder and make it to what we would say is the Supreme Court. Now, every case cannot go to the Supreme Court, right? No matter how unfair you think it is. There are procedures and there are things that they have to qualify for that. But we're going to see when we look at these landmark cases that sometimes, someone who doesn't have a lot of experience or a lot of legal knowledge can make their way to the Supreme Court if the case has what it needs in order to do that. So, what is the purpose of the judicial branch? So I'm talking about federal courts. Basically, they decide the meaning of the law and they decide the meaning of the Constitution. Now that seems weird, like we already know what the Constitution is. What do you mean? Well, sometimes people disagree about what our founders meant by their wording in certain areas. And we're going to see that in those landmark cases. And so they get to decide, the judicial branch gets to decide basically what they meant and how we have to follow those things that were put in place all those years ago. All right, so we know that there are 9 justices because that was on your citizenship test, and you know that they don't have a term necessarily. They serve until they retire, or they die, or they can be impeached, but that hardly ever happens. The Constitution actually says something like they will serve as long as they're behaving or something like that. That's the terminology, behaving. So as long as they're not committing crimes, they're probably not going to be impeached. So that is an important thing to note. Another thing that the framers knew is that if they were elected by the people, they would be more likely to do what the people wanted so that they could be reelected. Like we were talking about when we did the legislative branch, we were talking about the case about smoking. And if you are a senator from an area that has their biggest job center is a tobacco field or a cigarette factory, that you sort of feel like you're supposed to represent the people, even if it doesn't line up with what you truly think. Well, this is a totally different situation. And they didn't want the Supreme Court justices to feel like they had to do something that the people would like so that they could be reelected, or even as a thank you for being elected the first time. That this job was not about doing something for the people. This job is about interpreting the Constitution properly and interpreting the law properly, not about representing people. So they set it up in a way that Supreme Court justices are not elected. They are appointed. So when a Supreme Court justice retires or dies, or in those rare cases is impeached, then the president at the time gets to decide who he wants to be the fill-in for that person. Now, because we have that checks and balances, he can't just put his best friend in there who's never even been a lawyer, right? First, there are qualifications, but he also has to get the Senate to agree with him. So he puts the person up, the person goes in front of the Senate, They look at his qualifications, they ask him a bunch of questions, and so the Senate gets to decide if they're going to give the thumbs up on the person or the thumbs down. So a lot of times what happens is if you have a president who's a Republican, like right now, he's going to probably choose someone who's a little more conservative in his beliefs if he has to put in a new Supreme Court justice. If the Senate is also majority Republican, that will probably work out fine. If the Senate is majority Democrat, then they may not approve his choice for the Supreme Court justice. It gets very complicated. And so then he has to find someone who's maybe more middle of the road that can actually be approved by the Senate. Same thing if there's a president that is a Democrat, he's probably going to choose someone who's a little more liberal in his beliefs, and then the Senate is going to have to approve them. So if the Senate is majority Democrat, probably not going to be a problem. If the Senate is Republican, majority Republican, they may not approve the person who's got a very liberal mindset. So this gets very complicated. It seems super simple, like the president just picks him and he's in, or her. But it's a little more complicated than that because you do have to get the Senate to approve. But in any case, we have 9 Supreme Court justices who have been appointed by presidents, approved by senates, and they are there until they retire or die, or in the rare cases, are impeached. So in your We the People book, they talked about what judicial review was, which is what we were talking about, that they can tell that a law that's already been passed is unconstitutional. They could say that a part of the Constitution isn't being followed correctly. Let's say, for example, that they gave you an example in your book that suppose Congress passed a law that said you must participate, you must practice a certain religion. Like if they came in and said, everyone is Catholic or everyone is Jewish and you don't have a choice because we said it. Well, that clearly goes against what our Constitution says. So it would just take one person saying, hey, wait a minute, we need the Supreme Court to hear about this and make a decision. And they, of course, would decide you can't do that. People can be any religion they want, or they can be no religion at all. That's their choice. So sometimes, we talk about laws that are in Congress trying to be passed, and sometimes people think, oh, no, that you can't do that. Well, they can. But if it turns out to be unconstitutional, it's the job of the Supreme Court to come in and say, you can't do that. And then the law cannot be enforced. One interesting thing is that it talks about is that the Supreme Court makes decisions. They don't enforce those decisions, right? They're sitting in the Supreme Court room at the Capitol building, and they don't go out and make sure that everything they said is being done, right? That's the job of the executive branch. But they do make the decisions. And if decisions aren't being followed, someone will certainly come back to them and they will make that decision a little more, solid and make sure everybody understands what they're supposed to be doing. Okay, so are there limits? I mean, can these 9 people just do whatever they want? Well, of course not. Because as we said, they can be impeached. Hardly ever happens, but they can be impeached. And then the president, again, is responsible for enforcing those decisions. So that's sort of a balance as well. But the other thing is, there are 9 of them. That in itself is a balance, right? One Supreme Court justice cannot make some grand decision all by himself or herself. You have to have majority. And sometimes you have cases where it's 5-4 and it's just barely a majority. And sometimes you have cases where it's 9-0 and it's really clear that everybody agreed, kind of rare. And then sometimes you have cases where all 9 don't even vote, which we'll talk about momentarily. Okay, now we are going to talk about this court case, I think in a Zoom. I can't remember what day right now, but we will. So make sure you read that. But we're going to go ahead and talk about these 3 landmark cases. So there are actually 4 on your paper, but we're going to not talk about Roe versus Wade. We're going to leave that one alone. So the first one that we're going to talk about is Engel versus Vitale. So Basically, this goes to that religion sort of idea. And it was back in the 1960s. And 1962, it says. And there was this, it was actually New York had come up with this prayer. And I looked it up because I wanted to know what it said. Here's what it said. Almighty God, we ask, oh, no, rise. Almighty God, see, I don't have my glasses on. We acknowledge our dependence upon thee, and we beg thy blessings upon us, our parents, our teachers, and our country. Amen. Now, the first thing that strikes me is it doesn't seem to be based on a certain religion. Like anyone who's Catholic or Baptist or Methodist or Jewish or anybody could pray that prayer without being sort of against their religion. Like it doesn't sound like it's got a doctrine underneath it, holding it up. It's basically saying, dear God, can you put your blessings upon us, our school, our parents, right? Our leaders, our country. And so it's pretty, just generic is a word I would use for it. The second thing was, it was totally voluntary. So there was this time where you said the pledge, and then you could say the prayer. You didn't have to say the prayer, but you had an opportunity to say the prayer. Now, I'm going to tell you from a personal experience how that can be weird. Okay, so when I was in school from 5th grade to 12th grade, my BFF was a Jehovah's Witness. And Jehovah's Witnesses do not believe in saying the Pledge of Allegiance. So every day from 5th grade to 12th grade, that's the time I was in that town, we would say the Pledge of Allegiance, and she would not. Because she doesn't have to, right? It's not like a law. But what do you think people said about that, or thought about that, or kind of talked about her maybe behind her back because she wasn't doing it, right? It makes a person stand out, not in a probably positive way, when they aren't doing the status quo, when they aren't doing what's sort of the regular activity of the day. So while you could say, if you don't want to say the prayer, don't say the prayer. There were kids in that school who felt uncomfortable with that. And so their parents went to the Supreme Court and said, listen, you can't do that. You cannot tell my child they're supposed to pray in a school because a school is run by the government, right? There's a separation of church and state. The government should not make any religion. So why did this school system make a prayer to God? And so this was, Engel, by the way, was the leader of the parents who were complaining. Vitale was the school board president in this particular school district. So Engel versus Vitale, that's what that means. So it was 6-1. Everyone didn't even vote. 6-1 was the vote after they heard the case. And they said that they agreed with the parents. And Justice Black, who was the one writing the decision out, said that the majority of the court said, in this country, it is no part of the business of government to compose official prayers for any group of the American people to recite. So he agreed with them that as a school district, you can't say we're supposed to pray. Now, I know what some of you are thinking. We pray at the Covenant Preparatory School. Yes, we do. Because we're not supported by the government, right? This was an issue of government and church, and a government pushing a church on a group of people that had no choice but to go to that school, right? Like, this is the school that I'm zoned to. This is where I have to go. In our case, we are not supported by any government entity. We are a Christian school by definition, and so parents who send their children to the Covenant Preparatory School know that they're going to learn Bible lessons, they're going to learn Bible verses, they're going to pray, because that's part of our mission, right? So a decision like Engel versus Vitale does nothing to change a private school, but it did a lot to change the public schools. And that's why public schools today, you do not pray. I remember when I taught in Channelview, we did have a moment of silence, which was just exactly that. They would come over the PA system and say, now we will have a moment of silence. Everybody sat there, and you could pray if you wanted to pray. You could stare at space if you wanted to stare at space. You could stare at space and pretend you were staring at space and pray if you didn't want your friends to know you were praying. Like, you could do whatever you wanted as long as you were quiet. But I, as a teacher, could not stand up there and voice a prayer in a public school. And I couldn't tell you as a public school student that you have to say this prayer because, again, it's a separation of church and state. Now, by the way, while this case was being heard, the governments of 22 states reached out to the Supreme Court and said, please do not agree with those parents. We should be able to pray in our schools. So this probably was not a very popular decision at that time. A lot of people, not just parents, 22 state governments said, we don't want to take prayer out of our schools. But once the decision was made, nobody had a choice, right? You have to do what they said. So that was a landmark case because it really changed the way that schools did that sort of thing. Okay, next case, Gideon versus Wainwright. So you had this man, this was the actual crime happened in 1961. The Supreme Court case was heard in 1963, but you had this man, it was in Florida, and his last name was Gideon, thus the name of the court case. Wainwright, by the way, it was the Secretary of the Florida Department of Corrections when the case got to the Supreme Court. But basically, this crime was committed. Clarence Earl Gideon was arrested and charged with the crime. And he actually, in the courtroom, he said, excuse me, may I have a lawyer? And they said, no, you can't, unless you can afford one. He's like, I feel like I'm supposed to be able to have a lawyer. And they said, oh, that's only if you're charged with a capital crime, like murder, right? Something like that. So sorry, you can't have one. Now, I digress. I went in my We the People book and I flipped back to the Constitution. And I noticed that in Amendment 6, which was written in 1787, right, with the rest of the Constitution, which is way before 1961, it says, this is the very end of Amendment 6. The beginning says, in all criminal prosecutions. Did that say capital crimes? No, just crimes. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial, a jury trial, blah, 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 blah. And then at the very end, and to have the assistance of counsel for his defense. So all accused people have the right to the assistance of counsel, okay? And this guy seemed to know that, but the court did not seem to know that down there in Florida. And so they tried him for this crime, and the crime was a burglary, if I'm not mistaken. Let me look back. Yeah, someone broke into a pool room and they stole some stuff. So it was a case of theft. Not a capital crime, but a crime. So he was convicted and he was sentenced to 5 years in jail. And while he was sitting in jail, now I want you to know, they called him a drifter. A drifter, as in someone who probably doesn't have a home, right? Homeless. Like, he didn't have any money. He didn't have money for a lawyer. So he gets sentenced to 5 years. And while he's in jail, he goes to the jail library and starts looking through these legal books. And he's like, boom, see, I was supposed to get a lawyer. I knew this wasn't right. So he wrote a letter to the Florida Supreme Court saying, can you please, I need to appeal my conviction because Now, normally a lawyer would do that, but he didn't have one because they didn't give me a lawyer. Florida said, no, you can't have one. They were right. And so from his jail cell, this not lawyery person wrote another letter to the United States Supreme Court and said, here's what happened. I did not get a lawyer. I appealed it to the state of Florida. They said I couldn't have one. I think they're wrong. Please help me, right? So the U.S. Supreme Court agrees to hear the case. And so in 1963, he gets a lawyer because the Supreme Court appointed one to him. And after listening to both sides, the Supreme Court ruled unanimously, that's 9-0, that they would reverse his conviction because he had been denied an attorney. According to Justice Hugo Black, which was the same one who did that other ruling, a person on trial who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. He was given a new trial with a court-appointed attorney in his local area, and in the second trial, he was found not guilty. Now, to us, this seems unbelievable. Like, how could you tell him he can't have a lawyer? I mean, if you watch Law and Order one time, you know you have a right to an attorney. But in 1961, that was maybe a little more cloudy for them, right? This is the case that made it clear to everyone in the United States. Everyone who is accused of a crime, if you cannot afford a lawyer, one will be appointed for you. Now, that was not going on all across the country. So when it happened, this is a landmark case because it caused so many changes. Imagine the governments or the court systems, local court systems, who maybe were having to provide a lawyer for only people who committed a murder. Now they're having to provide a lawyer for anyone who has any kind of criminal like background, right? Anyone who's been accused of any sort of crime. So the justice system changed very much after this landmark decision. So that was Gideon versus Wainwright, 1963. Okay, and then the last one was in 1966. And it kind of started out similarly in that this man, Ernesto Miranda, was accused, he was arrested in Arizona, accused of kidnapping and assaulting an 18-year-old woman. And he goes to the police station, there's a lineup, and the victim says, oh, that's him, right? And so they start to question him. And after about 2 hours, he confessed to the crime and said, okay, I did it. And so they used, of course, the confession in the court case, and he was convicted of, sorry about that, he was convicted of the crime. And so he goes to court, he goes to jail, and then I went back to my We the People book. Fifth Amendment. No person, this was written in 1787, way before 1966, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. That's not the right part. Think about militia, nor shall be compelled in any criminal case to be a witness against himself. So it says you do not have to say things that show that you're guilty. I know you've all heard someone say it on the stand. I plead the fifth. That means I'm not going to answer that question because it could make me look guilty. Now, sometimes you might argue by saying that you already look guilty, but that's not the point. You do not have to say anything that's going to make yourself look guilty. It's in the Bill of Rights, Amendment 5. So Miranda thought that his Fifth Amendment right had been violated because when he was first arrested, they just kept hounding him, right? And he kept talking and talking, and finally he confessed. And so later, people started to wonder, should he have been told, hey, listen, you don't have to say anything, because if you do, we're going to use it in court. I know that just rung a bell in someone's ear. I've heard that before. Yeah. Also, that whole attorney thing, he did not have an attorney with him when he confessed. It was just him and the police officers. So this case Miranda versus Arizona was not a unanimous vote. It was 5-4, the closest you can get in a Supreme Court case. And they did overturn his conviction and said, okay, that was not a fair trial because you were not informed that you didn't have to say anything. Speaking for the court majority, Chief Justice Earl Warren, so we have a new Chief Justice at this point, said that the Fifth Amendment right not to testify against oneself belongs to a suspect seized by police. At the time of being seized by police, the suspect must be clearly warned that he may remain silent, that anything he does, say, can and will be used against him in a court of law, and that he has the right to consult with a lawyer before and during questioning as provided by the Sixth Amendment. Now, Law and Order, Dateline, whatever you watch. You've seen it, I know you've seen it. Someone's putting the handcuffs on the guy and they're saying, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed for you, right? Those are called Miranda rights because of this case, Miranda versus Arizona. So, this is a landmark case, right? It is everywhere. This guy is famous because of all of this. The Miranda rights are a direct result of that Supreme Court landmark case where they said people don't have to testify against themselves, and you have to tell them that at the moment that you arrest them. So when you arrest them, you have to tell them you have the right to remain silent. Now, do you have to remain silent? No, and a lot of people don't, and they still confess and they still incriminate themselves, but at least they've been told that they have the right to remain silent because anything they say will be used against them in a court of law. So those are the three cases that you are going to be answering the true and false questions for. And every tiny piece of detailed information that you need to answer those questions is in those tiny little couple paragraph blurbs about that case. So read them carefully consider whether that's true or whether that's false, and write your answer, and then you'll send me a copy of your answers by Sunday at 4. Okay, everyone have a really great week, and we'll talk to you later. Bye.